grounds or the fact of divorce. Where the parties have come together with a view in mind that they want to reconcile their differences. If they come together for periods that are more than 6 months, then subsequently, none of the spouses can go to court and say that we did not live together for 5 years, so we want a divorce. Because you have managed to live together for more than 6 months to attempt reconciliation after you have not lived together for either 5 years or 2 years. So long as after the fact has happened, you attempt reconciliation. And as a result of that attempt at reconciliation, you come together. If the period within which you are together is not up to 6 months, then thereafter, you may still petition the court for divorce on the grounds that you have been separated for either 2 years or 5 years. However, if the periods with which you live together continues for more than 6 months, and in this regard, we do not use the word continuous. The 6 months is cumulative. So it can be 3 months, 3 months, 2 months, 2 months, 2 months, 1 month, 1 month, 1 month, but for a cumulative period of 6 months. So when all those periods are added together and they come up to 6 months, but they do not exceed 6 months, then you may still go to court for divorce on the grounds that we have not lived together for this number of years. And although we attempted settlement, we did not live together for 6 months. So please grant the divorce, and the court would do so. We move on to the next ground of divorce, which is called the inability to reconcile differences. Inability to reconcile differences. Now, I did mention that the list I gave was not an exhaustive list. So where you find out that the facts that you are complaining of, do not fall under any of the situations I have mentioned, there is a last ground termed the inability to reconcile differences. Here also, we must emphasize that the differences being spoken of are not the normal arguments that couples have daily. These are grave differences based on which the couple find it intolerable to live with each other. Those will be termed inability to reconcile, or those will be termed irreconcilable differences. That should be the word, irreconcilable differences. And like I said, they are not the normal wear and tear of marriage life. Neither are they the normal arguments that couples normally go through. There is a caveat, however, that before you may come under this particular fact for the court to grant the divorce, you must prove to the court, and the word is must. That means it is mandatory, not obligatory at all. You must prove to the court that you, when I say you, the parties, or their friends, or their families, or their lawyers, whatever, have tried to settle the differences. That is why we say irreconcilable. Irreconcilable meaning that everything has been done, but the differences cannot be reconciled. The two parties cannot be of the same heads when it comes to separate issues, to the detriment of one spouse or the detriment of the other. So you need to establish to the court that you have attempted to settle your differences, but those attempts failed. In addition to the above also, whatever lawyer you choose, then this goes for both parties, the lawyers must also inform the court that they have been witnesses to attempts at reconciliation. So in addition to you proving to the court that you attempted reconciliation, your lawyers must also inform the court that reconciliation was attempted and the parties did not, or the parties were unable to reconcile their differences. That concludes the first part of our discussion. That is the dissolution of marriage by ordinance. We now move on to the distribution of properties after divorce. We start with what constitutes spousal property. And for the purposes of this discussion, we would group spousal property into 4 thematic headings. We have what we call the family property, the household chattels or household property, property acquired before marriage, and property acquired during the pendency of the marriage. Spousal property is just defined as any property that is acquired by a spouse or that is acquired by both spouses during the pendency of the marriage. During the pendency of the marriage. We must make the distinction that it is not every property acquired by a spouse or acquired by both spouses during marriage that will form part of spousal property. And please, when I use the word acquire, I am not making reference to the physical acquisition. Acquire can be you physically purchasing the thing or the thing coming to your possession by whatever means. It will be termed acquisition. Now, the following instances have been held to be instances where the properties will not form part of spousal property. So, for instance, a gift given to one spouse for his or her benefit alone will not constitute spousal property. Also, an inheritance, when property is willed to one spouse under a will, or when one spouse is granted property on the death of a relation or on the death of a friend or on the death of whoever, that property or that inheritance belongs absolutely to the person it was given to. It does not form spousal property and it does not belong to both spouses. Also, trust or settlements. When a trust is created in favor of one spouse, or when a settlement is made in favor of one spouse, that does not form part of spousal property. It belongs to that spouse absolutely. Unless, and please emphasis on unless it is proven that the trust or the settlement was created for the benefit of both spouses or for the benefit of the children of the marriage. Under that circumstance, that gift will form part of a spousal property, because although it's a trust or although it's a settlement, it was given for the benefit of both spouses or for the benefit of their children. So, for instance, if you inherit a house and under the will, it is indicated that you are to hold that property on behalf of your children, then that property does not belong to you. It forms part of spousal property, which belongs to the children of the marriage. Also, money or insurance policy taken out in favor of one spouse, it belongs to that spouse alone. Certain personal effects have also been held by our courts to be property that belongs to a spouse alone and not spousal property. Business assets, and this is very, very important. You normally hear somebody say, oh, my husband has this company and therefore this company belongs to us. No. Business assets belong to the business. The company is an entity on its own. The company is not spousal property. Business assets or business property belongs to the business. It is not a spousal property. And also, where the couple have a contract under which they have clearly indicated their individual properties, then those properties under that contract will not be spousal property, but will be deemed to belong to that spouse absolutely. Okay. Now, after defining what constitutes spousal property, we now come into the four thematic areas I mentioned previously. Family property. Now, family property is defined as, and for our purposes, when we say family, we're referring to the extended family. When I'm making reference to a couple's family, I will specifically say so. Family property. Now, the position of the law is that when one spouse owns property that belongs to his or her extended family, and the other spouse makes certain contributions or makes certain development or makes certain additions to that house or to that property, then that other spouse becomes a beneficial owner. Now, when we say beneficial owner, what we are simply saying is that, yes, on paper, the property belongs to Kwame Danso's family. But because you have spent so and so and so amount of money to improve it or to develop it, then the law will recognize that you also have a certain amount of ownership in that property. So Kwame Danso's family cannot deal with that property in any manner without your consent. So although that property does not necessarily become spousal property, upon divorce, you are entitled to a share of that property because of the contribution you made to develop or to improve that property. We move on to household chattels or household goods. Now, these have been defined under the Interstate Succession Law 1985, PNDC Law 111, as any household goods that would include jewelry, clothing, furniture and furnishing, television, radiogram, electrical appliances, etc. Things that couples normally use in their matrimonial home. These are household goods that form part of spousal property that belongs to both couples. Now we come to the position of the law with regards to property acquired before marriage. Now the position of the law is that any individual of sound mind and sound body of the right age being 18, is allowed to acquire property on his own or her own volition. So any property that an individual acquires before marriage belongs absolutely, emphasis on absolutely, to the person who purchased or who acquired that property. So when a party owns a house or owns a vehicle, and after marriage, both couples move into that house, in the absence, and please, this is very, very important, in the absence of any contrary evidence to indicate otherwise, the law presumes that the property belongs absolutely to the person who acquired that property before the marriage. Here also there is a caveat. If after the marriage, we move into the house which belongs to you, and the house starts deteriorating, and the other couple makes a substantial contribution to the renovation of the property, or even if the house is not crumbling or whatever, but the other couple adds or contributes to the development or to the expansion of that property, then the position of the law changes. The property no longer belongs absolutely to the one who acquired it before marriage. The person or the spouse who has made the contribution also acquires a beneficial interest in it. We keep on using beneficial interest because under normal circumstances, that property will be registered in the name of the person who bought it. So what the law is saying is that, yes, your name is not on the document. But because of this contribution you made to the renovation of that property, and by virtue of the fact that you made those contributions because of the marriage you are in, then under that circumstance, the spouse will own a share in that property, even though the property had already been acquired before they got married. Then we move on to property acquired during marriage. Now, this is a very interesting area because a lot of the matrimonial issues are dependent on the understanding of this particular topic, property acquired during marriage. I will give a little background on how far we have come. I will do a translation afterwards. So those of us who are non-accounts, I do apologize. There is a popular account adage that goes by Oba die okwaware wambepe ejapadie. To wait, a woman's aim is to go into marriage, or a woman's aim is to get married, not to acquire property. So previously or prior to recent times, the position of the law was that whatever a woman helped the husband acquire whilst they were married belonged absolutely to the man. So if the couple had a very large farm, and as pertained most in our homes, you will find the woman or the wife and the children doing most of the labor on the farm, with the husband lazying away in his favorite lazy chair with a pipe and swatting away flies. Even where the woman has contributed substantially to the growth of the farm, the law was that everything belonged to the husband. That is why we used to have what we call ejapa die, which only means what my good father has given me. We didn't have enapa die. It was always ejapa die, ejapa na die. The law recognized this was unjust. Sorry, this was unjust. Pardon the wrong usage of the word. The law recognized this constituted injustice in that, in most, as I explained, you will find the woman doing the majority of the labor, and then upon divorce, she is left penniless just because the law was that she is a woman and she just went to help the man acquire property. So the position of the law changed from that to what we call substantial contribution. Now, the law recognized that in certain instances, the wives, please pardon my continuous usage of the word wives, because admittedly, and to admit, the law has been unfair to our women for a very long time now. In most instances, it was our women who suffered a lot of the grave injustice whenever divorce happened. So I will keep on using wife and woman because in reality, that is what pertains. That's not to say that men do not also go through what I'm talking about. Now, the position of the law then shifted to where you now have to show that you made a substantial contribution to the property. So now, the woman who contributed to the growth of the farm now gets a share of the farm because the law recognizes that she contributed substantially to the acquisition of that property. The injustice in this was that it was difficult to determine what constituted substantial contribution. It was quite difficult what constituted substantial contribution. It was held that a woman performing household chores that allowed the man to go acquire property did not constitute substantial contribution. It was quite unjust. They also said that the contribution has to be towards the acquisition of the property. So if the man acquires property on his own and the woman uses her money to take care of the home. Upon divorce, the property was deemed to belong to the man because the woman's contribution was a contribution to the maintenance of the home, not a contribution to the acquisition of that property. You would agree that was also unjust. However, one thing that the court did, which helped a lot, was that the court did not rely on the normal conditions that it attaches to business relations. So under normal circumstances, if I want to say that I'm an owner of this house, and you say, no, you are the owner, and I say, no, I paid so and so amount for the property to be acquired, then I need to show by bringing receipts of payment or bringing receipts of the materials I bought for the acquisition of the property, so the court can hold that indeed I contributed substantially. However, when it came to marriage, the court held that the relationship of marriage is so unique that you cannot apply the normal business relations to the institution of marriage. So in the instance where one couple, here again the woman, was unable to produce any receipt to show that he or she made a contribution to the acquisition of the property, the court still held that the failure to produce a receipt would not mean that the person did not contribute substantially, but the court will make the inference from the facts surrounding the acquisition. Typical example, husband is in Germany, Italy, Netherlands, continental Europe, wherever, sweating away. Wife is home, taking care of children. Husband has been sending money for the acquisition of a home. Wife has been the one supervising the building of that property. She has been the one going to buy the materials with the foreman. She has been the one making sure that the foremen are working in accordance with the time schedules given. Although she would not have any receipt to show that she bought A, B, C, D, the court has held that that act of making sure that the house was put up, even though she did not contribute financially, she owned a share of that house. That was what the court arrived at when it gave the rule that there has to be substantial contribution. So substantial contribution need not be monetary contributions only, but it must be something that is done towards the acquisition of the property. Once again, the law realized it was quite unjust. So the position shifted to what is now termed equality is equity. Most of the references I have made were made prior to the passing of the 1992 Constitution of Ghana. Now, when the Constitution was passed in 1992, the framers recognized how unjust the position of the law was regarding the rights of women during divorce. So yes, a provision was made in the 1992 Constitution. Article 22(3)(a) and B, and it should appear on your screens in the slide. So I'll quickly read through it. We are quite behind schedule. So I'll quickly read through it. It provides, a spouse shall not be deprived of a reasonable provision out of the estate of a spouse, whether or not the spouse died, having left a will. This has to do with the event where one spouse dies. Whether the spouse leaves a will or not, the surviving spouse has a share in whatever property has been left. Clause 2, Parliament shall, as soon as practicable after the coming in force of this Constitution, enact legislation regulating, please hold on a minute. Parliament shall, as soon as practicable after the coming into force of this Constitution, enact legislation regulating the property rights of the spouses. Clause 3,
with a view to achieving the full realization of the rights referred to in clause 2 of this article. Spouses shall have equal access to property jointly acquired during marriage. I repeat, spouses shall have equal access to property jointly acquired during marriage. And B, assets which are jointly acquired during marriage shall be distributed equitably between the spouses upon dissolution of the marriage. So that is where we got the phrase, equality is equity. That is where we got the phrase from Article 22, Clause 3, A and B of the 1992 Constitution. And to read again, with a view to achieving the full realization of the rights referred to in Clause 2 of this article. A, spouses shall have equal access to property jointly acquired during marriage. And B, assets which are jointly acquired during marriage shall be distributed equitably between the spouses upon dissolution of the marriage. Unfortunately for us, despite this provision being made in 1992, our parliamentarians have failed to enact specific legislation in accordance with Article 22(3)(2) that will regulate the distribution of spousal property. Our courts, being as judiciously active as they are, have taken it upon themselves to act where Parliament has failed to act. So our courts have, in a number of cases, interpreted Article 22(3) to give effect to the intention of Parliament when this particular provision was being made in the Constitution. I now take you through a number of very important cases that have shifted or that have shaped the current position of the law regarding the distribution of spousal property upon dissolution of marriage. The first in a series of such cases is what we popularly call the Mensah and Mensah. It was a case in which judgment was delivered in 2012. This is the first case where our courts moved away from the previous requirement of substantial contribution and applied the provisions of the 1992 Constitution to distribute spousal property equally, although there was no proof that the other party had made a contribution to this acquisition. Three important rulings came out of that case. The court held, due to the constraints of time, I'm unable to go through the facts of the case and all of that, but those can be made available upon request after this presentation. If anybody wants any material that reference was made to, so you can read on your own, please, that request can be made and Charles will attend to you thereafter. Thank you. One of the main rules that came out of the Mensah and Mensah case was that the court moved from the requirement to show that you contributed to the requirement that any property that can be proven to be spousal property should be shared on a 50-50 basis upon dissolution. So whether you contributed or not, so long as the property was acquired during marriage, then upon dissolution, it is shared 50-50. So in that instance, the second principle came out. Equality is equity. That was the equality is equity principle, that in order for both parties to be on equal footing, or in order for justice to be done to both parties, then we are sharing the matrimonial property 50-50. Another very, very important decision that came out of Mensah and Mensah was that, contrary to the previous holding or the previous law, that you will need to show substantial contribution and the contribution has to be towards the acquisition of the property. Now, you no longer need to show that the contribution was towards the acquisition of the property. In this particular instance, the wife did not contribute materially. neither did she contribute in cash or expend labor towards the acquisition of the home. But the court or the judges found that she provided such a benign, such a convivial, such an environment where the man had the peace of mind to go out, to go and work and get money to acquire the property. So the court held that when the woman held the home, she makes sure that the house is clean. She does the man's laundry. She does the laundry of the children. She cleans the home. She cooks for the home. She makes sure that the children are dressed and taken to school. She makes sure that the children are sent to the hospital when they are sick. All of this will be deemed to be contribution towards the acquisition of the home. So some justice was done in that, although the woman could not prove that she contributed financially to the acquisition of the property, she could prove that she was doing domestic duties while the man was having the peace of mind to go and acquire the property. So the court held that that domestic duty that the woman was performing was enough substantial
the last time you said?
Based on which the court held that they are entitled for the part to be shared on a 50-50 basis. So the court just held that household chores can be substantial. That was in Mensah and Mensah. So you realize that some form of justice has begun.
Your husband attend church.
After Mensah and Mensah,
your husband attend church.
But we want to make reference to another one. Arthur and Arthur. Now, Arthur and Arthur reinforced the position that was arrived at in Mensah and Mensah. This is where the court made the distinction, and I've already made reference to examples of properties that would not form part of matrimonial property. It was in this case that the court made the distinction that yes, not every property that is acquired by the couple during the subsistence of the marriage would form spousal property. And the example I gave was the gifts and the inheritance and all of that. Now, in Arthur and Arthur also, the court made a significant distinction of their previous decision in Mensah and Mensah. The court held that it is not in every instance that the properties will be shared 50-50. Once again, the court recognized their previous, and I'm using error in a loose way for want of a better word, their previous error in making a blanket statement that every matrimonial property should be shared 50-50. The court recognized that there would be certain circumstances that would make it unjust for the properties to be shared 50-50 between the spouses. So in Arthur and Arthur, what the court said was that the presumption is that property acquired during the subsistence of a marriage belongs to the couple equally. However, depending on the circumstances of the case, the court will not order the property to be shared equally. So that presumption of property belonging to the parties equally can be rebutted by evidence presented to the court, which would prove to the contrary that the property was not meant to be shared equally. Then again, in fin and fin. So you see, the beauty of it is that as period emerges and as new developments come, the court continue to develop the law. After Arthur and Arthur came fin and fin, and all the current decisions that have come under fin and fin are all premised on this particular case, fin and fin. In fin and fin, the court reiterated its position that it is not in every instance that property will be ordered to be shared equally. So the underlying principle that equality is equity is only a presumption. And when we say a presumption, it is only a statement that is allowed to stand in the absence of anything to prove otherwise, or in the absence of evidence to the contrary. So the presumption will only hold if there isn't any evidence to show that the presumption should not be applied. So in fin and fin, the court did not apply that presumption of property being shared equally. In fin and fin, the court made the distinction that the same constitution that has given, or the same constitution that has made it clear that property acquired during the pendency of a marriage belongs to both spouses, that same constitution recognizes the right of an individual to acquire property on his own. So in fin and fin, the court has recognized that even when parties are married, the parties are allowed to acquire properties on their own, and those properties will not be deemed to be spousal property. A typical example is a household where the man and the woman have different accounts. They run strictly separate accounts. Each of them contribute separately to the maintenance of the home. For instance, the man takes care of the bills, the health, maintenance, or whatever of the issues of the marriage, and the woman then takes care of the domestic needs, groceries, and all of that. It is also shown that during the marriage, the parties have consented to acquiring properties on their own. Then, under such circumstances, the court will not hold that those parties should be shared equally, because the parties themselves have exhibited to the court that they used to own property separately when the marriage was in existence. So that was a distinction made in fin and fin, that it is not every property that will be ordered to be shared equally. In certain circumstances, one party can get 60%, one party can get 40%, one party can get 30%, one party can get 70%. Also, there will be an instance where one party may not benefit at all from the property because during the marriage, the parties have, or the parties had a habit of acquiring properties separately on their own. So now the present position of the law is that property acquired during the pendency of the marriage belongs to both parties, and both parties shall have an equal access to that property, or shall have an equal share of that property, only to the extent that it will be equitable and just to do so. Equitable in layman parlance would be pepe or pepe, without cheating anybody. However, if there are circumstances to show that the principle of equality is equitable, then the court will do so. So there would be circumstances where the properties will not be shared equally. But the beauty of it is that no matter what, one spouse will definitely have a share in the matrimonial home, contrary to the previous positions where the law was that it's only a husband who can acquire property. Now, the court takes various factors into consideration when deciding to, or when determining which share to give to which spouse. Once again, there are many other factors which I have not added to this list. But the examples that the court will take into consideration include the duration of the marriage, the ability of each spouse to earn an income, the standard of living that the parties were used to before the breakdown of the marriage, the age of each party at the time of the divorce, which will affect the ability to earn income after the divorce, the financial resources that each person has saved, based on which the person can then live or continue with life after the divorce, unreasonable impoverishment by either spouse of matrimonial assets, situations where because the party is registered in only one person's name, for instance, if it's a rental accommodation, then that person will be collecting the rent and then spreading it alone without giving any share to the other party. The court will consider all of that when making orders as to what share should go to that party. Also, the amount of debt and liabilities that each party has and the circumstance in which the debt was acquired. So for instance, one party is so much in debt, but that debt was acquired for the benefit of the family. The court will take all of those things under consideration. The court also recognizes what is loosely called the prenuptial agreement or the marriage contract. If the spouses themselves have a prenuptial agreement and they have indicated inside that they decide what a property to be shared, and it is proved that there is no fraud involved, and both parties consented to the agreement and have appended their signatures, then the court will give effect to that agreement that the parties themselves have drafted. The court also looks at the needs of any children of the marriage and the age at which they are at the time of the marriage. And the court also consider sometimes one spouse invests so much into the development of the other spouse. Example where one spouse had a much higher education than the other spouse, and then during the marriage, he or she made sure that the other spouse also attained a respectable level of education. The court will consider all of that when ordering how the properties are to be shared. Now, in addition to Article 22, based on which all these decisions have come out from the Supreme Court, there is also another piece of legislation in the MCA, which also takes care of how property should be shared when spouses are divorcing. We referred to Section 20 of the MCA. I've already made reference to the MCA. Now, the Section 20 has mandated the court to award, and those of you familiar with American literature and American culture, what is called alimony. Alimony. It is recognized under our laws. So in addition to the distribution of the properties, the court may also allow one spouse to pay alimony or to settle the other spouse. And the amount to be paid will depend on, or is at the discretion of the court, but it is based on a number of factors which the court will take into consideration. In the instance where a court orders money to be paid and the party on whom the order is made is unable to pay the money, then the court can then order that party to then transfer property to that party because they couldn't afford to pay whatever money has been paid. Now, this property is different from the property which is shared when the party, sorry, is different from spousal property. It's quite different. There is a very popular case where on divorce, the man was ordered to pay an amount of money to the woman. And in addition to that, the court also ordered that the man should also convey one of the properties to the woman. The man went on appeal on the grounds that he's being punished unduly because he cannot pay money and also transfer one property to the woman. The court held that no, Section 20 is such a way that you may be allowed or you can be allowed to pay money in addition to transferring property. So Section 20 is quite different from how property is shared. Section 20 is very, very mandatory. Okay. In addition to that, in addition to the Section 20, the MCA also makes it mandatory for one party to transfer to the other party property that does not belong to him or her. So the example I gave where I say the parties can acquire individual properties, that is very true. It's also very true that a court can also order, based on the circumstance of the case, for that party to transfer property which is not spousal property, but belongs to one spouse, to the other spouse as part of settlement or as part of financial provision to be given upon divorce. Also, during the pendency of the divorce proceeding itself, that is where the petition has been filed. Excuse me. Where the petition has been filed, there are instances where, or in most instances, one party relies on the other party, like just one party has been taking care of all the matrimonial obligations. And because you've gone to commence the divorce, that party decides to withhold the maintenance that he pays, or he decides to stop paying rent, or he decides to stop
providing for the maintenance of the home. The MCA makes provision for a party to apply to the court that even though the divorce has not been granted, the court should allow the spouse or my other spouse to be paying me the maintenance that he was paying whilst we were married. This is done to prevent or to make it easier for any party to initiate divorce, not fearing that because I've initiated a divorce, I will not be getting my maintenance money again. Also, the court has a power. If divorce proceedings have been initiated, the courts have a power to place a sort of injunction on one spouse to prevent him from dissipating or selling off any of the matrimonial homes. Most times, one party will initiate divorce proceedings, and before you realize, or before the case is over, you realize that the other spouse has sold off all the parties that would have been shared. Now, the courts have made it mandatory that once divorce is initiated, you are under an obligation not to dissipate any of the matrimonial properties. You are also under an obligation, and it goes to both parties, not to take any of the children of the marriage out of the country once divorce proceedings have been initiated without permission from the court. All of this is done to protect the weaker party when incidents of divorce have been initiated. Yeah. And last but not the least, the court also has a power. For instance, when divorce proceedings have been initiated and one spouse lives out of the jurisdiction with any child of the marriage, the court has the power to order that spouse out of the country to return the issue of the marriage pending the final determination of the divorce proceedings. Okay. Yes. I believe that will be the conclusion to what has been a very lengthy seminar. We should have been done around 12:30, and I do apologize for that. We now make room for questions and answers. Anybody with an issue or anybody who did not understand any of the issues we raised may do so. I do realize that some of you already sent some questions. So as much as possible, I will read them out for the benefit of everyone, and then I'll proceed to answer them in the manner in which they were sent. Okay, I've seen a number of requests asking for the presentation to be sent. I will discuss and then we would respond to that. Okay. Just moving. Okay. So I have a question from Atuma Afo. Her question is, does desertion apply in the dissolution of a registered customary marriage? What happens in situations where one of the spouses cannot be traced after about 8 years? So this question is twofold. I failed to mention, due to time constraints, that the MCA is also applicable to customary marriage. What this means is that even when you are married under customary law and you have registered that customary marriage, then yes, you are allowed to petition for a divorce using the grounds that have been laid down in the MCA. So the simple answer to the question is yes, desertion would apply in customary marriage. Now, the second part, what happens when a spouse cannot be traced after 8 years? It is threefold. One, the desertion for 2 years has already been made, so you can apply for the divorce. 2, the desertion for a continuous period of 5 years, for the first instance, it might not apply because you said the party cannot be traced. Don't forget, for the first instance, desertion for 2 years, you will need the consent of the other party. Now, because you cannot trace that party, you will come under the desertion for 5 years. So you can go, this time you won't need the consent of the other spouse at all. You will just go straight to the court that I cannot trace my husband for the past 5 years after diligent efforts have been made. On a lighter note, there is also a presumption that when a person cannot be traced after a period of 7 years, after diligent efforts have been made to trace that person, it is presumed that person is dead. So in Aduma's instance, Aduma might either be a divorcee or a widow, depending on the circumstance of the case. So yes, 8 years, you can go for desertion after 5 years. And also there might be a presumption that your spouse has died if after 7 years, the spouse cannot be found. Okay. Now we have an answer from Nancy in KuukuaA. Nancy wants to know, okay, Nancy's question is, please, what do you do if you have less or no idea about the properties your spouse have acquired? If you have less or no idea of the properties your spouse has acquired. It is a bit problematic because the courts are only able to deal with what is presented before them. Due to the nature of litigation in this country, unlike certain jurisdictions where the courts upon themselves are able to do investigations, our form of jurisprudence is such a way that our courts are not advocates. So our courts are there for you to bring your case, and then based on the facts presented to them, the court will then make a determination of who deserves what. So unfortunately, as it might sound, the court will be handicapped if you're unable to bring before the courts the properties that have been acquired. However, the court also frown. The court frown, and I'll use frown in caps, on any spouse who purposely hides assets, knowing very well that a divorce proceeding is in the offing. In such instances, when the spouse is found out, he or she is ordered to pay sometimes triple-fold. So with Nancy's question, I would believe some diligence on all our parts would be required. But the law would also not leave you handicapped, because in most instances, yes, the party has hidden assets, but lifestyle, someone's lifestyle, for instance, the two of you are married, you are living in a rented accommodation, you have just one car between you. Then it is realized that, oh, although we are living in this dilapidated accommodation, this particular person frequently eats here, or he frequents this popular hangouts. Then yes, the inference will be made that no, there are some assets somewhere which have not been mentioned, and the court will deal dearly with whoever purports to do that. So Nancy, some diligence on all our parts will be required. We don't have to sleep on our rights at all. Okay. Now we move to a question from Ifua. Ifua's question is, land that had been acquired during the marriage but was put in only one spouse's name, can this be shared equitably? Yes, I did make mention of it, that so long as the marriage was acquired, so long as the property was acquired during the pendency of the marriage, then the other spouse has an equitable share in it, irrespective of whose name is on the document. Two cases arise. When a couple is married and property is acquired, but it is in the name of only one person, the law presumes what we call a resulting trust. All that this means is that even though you have your name on the title deed,
You are only a holder of the property. That is, you are holding the property for both our benefits. So yes, the other spouse whose name is not on it will be entitled to an equitable share. As to whether that equitable share will be equal will be determined by the court based on the circumstance of that particular case. So Nancy's, the answer is yes, the party will have an equitable share in it. Okay. We move to a question by Christina Amma. What happens if, B. What happens if the children are not Ghanaian, but the divorce is being initiated in Ghana? The children are not Ghanaian, but the divorce is being initiated in Ghana. Okay, so when I was discussing the petition, what goes into a petition, I mentioned that the couple will also have to prove that either they are citizens of Ghana, or they are residents in Ghana, or they are domiciled in Ghana. What this means is that before you can petition for a divorce under the MCA, one of the couple will have to be a Ghanaian citizen. Now, if both couple are not Ghanaians, but they reside in Ghana and they got married in Ghana, then yes, the law will apply to them. Now, if for whatever reason, one of the spouses is not Ghanaian and resides out of the jurisdiction with the children, but one spouse is Ghanaian and resides here, or the divorce proceeding was initiated in Ghana, then yes, the court can order the other spouse who is out of the jurisdiction to bring the children to the jurisdiction during the pendency of their marriage. It has happened before. There was an instance where the couple were, the man was Ghanaian, the woman was German. And then what happened? The children were naturalized German citizens, and the woman was living with the children in Germany. Now the man relocated to Ghana, filed for divorce here, and then under false pretenses managed to get the children here. He told the wife a story of wanting to take the children on an excursion in Ghana and brought the children here. Now, when the court granted the divorce, the court awarded custody of the children to the woman, not the man. The woman was then able to enforce the court's provision for the children to be taken out of Ghana to the Netherlands. So this was the other way around. But yes, the other way around is also applicable. When, for instance, the woman is here, the divorce was filed here, the man is out of the jurisdiction, and the children are naturalized citizens out of the jurisdiction, the court can allow the children to, depending on their ages. If the children are above the age of maturity, then it will be dependent on the children's own natural wish, what they wish, not what the parents want from them. But if they are younger children and one parent is a Ghanaian citizen, then yes, the courts do have the jurisdiction to compel the other spouse to bring the children into the jurisdiction. Okay. Now we have a question from Ifwa. Now Ifwa says, what if the customary marriage has not been registered? Can one party apply and be granted a divorce without the knowledge and the consent of the other party? The answer is no. The answer is no. You cannot apply for a divorce without the consent or at the blind side of the other spouse. Now also, for customary marriages, because of the different customs we have pertaining in this country, there isn't one blanket ways for the dissolution of customary marriages. No. Every area and the customary law that they use to dissolve the customary marriage. That is why the requirement is that when you register the customary law, it now comes under the MCA, and it is the requirement of the MCA that is pertaining to you. So for instance, if the two of us are Danby and we marry under custom, how our marriage will be dissolved is totally different from two accounts who have also been married and are also seeking a dissolution. So the marriage will have to be registered for it to come under the MCA, although it is customary marriage. And the answer to the second aspect of the question was no. Okay, so I'm taking one from Theodora Okai. Theodora wants to know. One moment, please. Okay, Theodora's question is that, no, I've already dealt with that. I think I dealt with that from Ifwa also. That where the land is registered in only for one person's name, and that person dies. Oh, okay. There's a little distinction. So in the case where land has been acquired during the marriage, but was put in only one spouse's name, and one spouse dies, do the children have any claim on part of property? The answer is yes. In fact, the children have a claim to both shares of their parents. So in the instance where the surviving spouse remarries, the children are entitled to the share of the surviving spouse in addition to the share of the spouse who has died. So even if it is in the name of one spouse only, the children are entitled to inherit that property. Okay. The question from Charlotte. I can see only questions from women, and is it that women are the only persons affected or interested in these topics, or are men just want to keep quiet and listen? Anyway, I will go. I have a question from Charlotte. Charlotte's question is, respectfully, is consent required for all divorces, except for marriages less than 2 years and desertion? Is consent, okay, now to understand the question or to hazard an answer, you do not need to seek a consent of the other party before you file a petition. That point has to be made. The couple are there. You have identified or you have gone through any of the facts that I enumerated earlier on. And to the best of your knowledge, you find it intolerable to live with the respondent. And also, despite all the effort that has been made at reconciliation, the marriage has broken down. You can initiate petition without going to seek the other spouse's consent or approval. Just that the court will ensure that you have notified, which is different from seeking consent. So the notification is that once you have filed or you have done the petition and it has been sent to court, the court will now ensure that you will send a copy of the petition to the other spouse so that he becomes aware that you have filed a divorce. But you do not need a consent before you go and file the divorce. Now, the issue of consent when it comes to the 2 years is that you are not seeking the other person's consent to initiate divorce blanket. No. It is because both of you have not, so it is specific. It is very, very specific. It is because both of you have not lived together for a period of 2 years. And you want to use that specific reason to go and seek divorce. That is where the law will say that then the other party will have to consent that, yes, we have not lived together for 2 years, and I am agreeing that the marriage has broken down. So please, that distinction is there. You don't need the other person's consent before you file the petition. No, it's only when you want to rely on the specific fact that you have not lived together or you have been deserted for 2 years continuously. That is when the other spouse
will have to consent. Okay, now I've seen a very interesting one from B. And please, this is the last question I'm taking. Okay, so I was going to address one last question from B because it looks very interesting. So I will take B and then I'll take 2 men. Then after that, we are done. Okay, so now B's question is, what happens when one party takes a mortgage facility to acquire a house during the marriage in the joint name of the spouse and the employer, and then divorce is filed? Let me take it again. What happens when one party takes a mortgage facility to acquire a house during the marriage in the joint name of the spouse and the employer, and then divorce is filed? The other spouse is entitled to an equitable share of that mortgage facility. The other, because one, it was acquired during the pendency of the marriage. Don't forget, we've already made the distinction that the spouse does not need to show that he or she contributed financially to the acquisition of the property, so long as it was acquired during the subsistence of the marriage, and so long as it is proven that the other spouse provided the environment for the person who did the financial contribution to acquire it, then the property will be shared equitably. So yes, even though the mortgage is taken out in there, so in this instance, it's even taken out in their joint names. So they have their joint names on the mortgage facility. So yes, they are entitled to an equitable share. As to whether it will be an equal share, the court will look at the circumstance and they will make that determination. Now I take from Mr. Mensah. Mr. Mensah wants to know, a couple is with 2 children, woman deserted since first year of marriage, married for over a decade now, and the man is jobless at the time of divorce. What are the obligations of the man then when divorce granted? To be honest, the question does not contain all the information for a holistic answer. But from what he is saying, what I can say is that, yes, this constitutes a ground for desertion. It does constitute. Now, I did make mention of the fact that our divorce laws were slightly skewed in favor of the men. Now, justice is being done to all parties. So there have been recent circumstances where the court, in finding that a woman earns more than the man, or at the time of divorce, the man was not working, the courts have held or have ordered the woman to be doing or to be providing maintenance. So it's not only a one-way affair. Where it is proven that the man is not working, has lost his job, or the woman is earning more than the man, then depending again on the circumstance of the case, the court can order the woman to be paying more maintenance than the man. So for instance, if it is rent, the court can order the woman to be paying the rent because the man has lost his job, or the man is not working, or the woman is earning more than the man. So it depends on the circumstance of the case. So Mr. Mensah, under such a circumstance, depending on how much the woman is making, the court may order the woman to be the one paying for the maintenance and educational needs of the children until such a time that the man is able to find a job. The court may also order the woman to pay settlement to the man, depending on the circumstance of the case. So it is not only a one-way street. Then I'm taking one last question from Mr. Daniel Inu. From so I'm taking from okay, so we have Nanaka text. Nanaka text wanted to know, as I indicated earlier on, this seminar was primarily on ordinance marriage. There are a series, or there are more events that we will do and would consider talking about customary marriage and Mohammedan marriage. But a simple answer to his question is that it will depend on the custom under which the couple married. It will depend. However,
However, don't forget that although customary marriage does not come under the MCA, Article 22 of the 1992 Constitution is applicable. And I already read Article 22, which states that a spouse shall not be left out of property acquired during marriage, and that property acquired during marriage shall be distributed equally or shall be distributed equitably. So even though customary marriage does not come under MCA, it is still regulated by the 1992 Constitution. So yes, property being distributed under customary marriage has to be done in accordance with Article 22 of the 1992 Constitution, and also in accordance with some of the cases that I mentioned at the latter end of the presentation. I do recognize that there are a lot of questions, but unfortunately we are restrained by time. What we'll do is that we will take some of the questions, and as much as possible, we won't answer them, and then we'll send them to you directly in the manner in which they were sent. We wish to thank you very much for your participation. In as much as we would have wished we would have gone on and on and on, we are restrained by time. So as I indicated earlier on, there will be subsequent events with more topical issues for us to address all the needs of everyone participating in this seminar. We thank you again for your participation, and I will leave you to the moderator of the event for our closing remarks. Thank you very much.
Good afternoon. Thank you everyone for your time, for joining us with today's presentation. And please be reminded that the recording will be shared on our website, which is KuukuaLegalConsulting.com. I'm sharing that with us right now so that everybody can see and visit. So I'm just trying to get the website ready for you. So you can visit the website where we are going to share the presentation from today. And also you can reach us on our WhatsApp or call. You can reach us on WhatsApp or call 0540-126-838. When a call comes through, we'll be ready to assist with any concerns and feedbacks that you have. Our next seminar or our next clinic is going to be happening in the month of September. So please be on the lookout. We are going to share the appropriate information. It is going to be on the New Land Act, the New Land Act that had been passed recently by the Parliament of Ghana. We are going to take our time and, like we did today, explain all of that for us. God richly bless you for joining us today, and have a very good day. God bless you. Bye.